As others have discussed here today, there are a lot of novel questions because the roadmap has changed. It's changed dramatically. The legal landscape we once knew in Web 1.0 and 2.0 just aren't applicable in this context. And I see a lot of questions about the transfer of rights and issues triggered, by anonymity and whether the holder has a legal right to sell their NFTs and how to navigate international IP laws. And these issues are compounded by the decentralized narrative that underlies Web3. There's no central authority ensuring that the rule of law is deployed consistently and continuously. And accountability often falls to the user base. And there's sort of this ethos in Web3 around keeping the community happy and doing that by keeping things open source and in some cases even building on what others have done without a license or without written authorization to do so. There's this general unwillingness to police aggressively. And so there's a big question mark around how you fix that. What is the future of enforcement going to look like? There's already this disconnect between traditional brand owners who are keen on protecting the scope of their rights and those in Web3 who don't see that as jiving with the goals of blockchain and the Web3 landscape. But from an IP perspective, much of what is being built today relies on brand identity to help distinguish it from the competition. And more than ever, it's really critical to have kind of a strong, unique brand you can rely on to give consumers confidence and to have a cudgel for use in stamping out truly bad faith, unauthorized use cases. We see a lot of use of copyright in this space, but copyright is really complex, and the bounds of fair use and the scope of the DMCA are being tested as we speak. And it's a useful tool as the space evolves, but I think we're likely to see a broader appreciation for an emphasis on brand rights and a more proactive focus on maintaining those exclusive rights. So to that end, I think some guidance on the scope and the limits of trademark rights will really benefit brand owners and accused infringers and platforms alike. So the place to start is whether protection for physical products extends to the virtual good counterparts, which I know is an issue that's come up multiple times today. Basically, can an IP owner stretch their existing trademark rights to cover electronic or virtual products, for instance, NFTs? So as several folks have already previewed, there's quite a bit of disagreement on this point. And the surge and trend in major companies refiling applications for their marks for virtual goods and services suggests that brand owners think the answer is no, that protection does not extend to virtual goods. And this is also likely a function of brands diving into Web3 and looking to protect themselves and create defensive perimeters. But not every brand owner has the budget or the requisite intent to use to file in all these new verticals. And the outcome of some of the recent cases that are percolating, like the Hermes challenge to Rothschild's Meta Birkin, will likely inform some of the strategy going forward. But a possible stopgap measure that the Trademark Office might consider implementing is a fresh version of its Technology Evolution pilot program that allows brand owners to amend the goods and services identified in their registrations. So you'll recall that this program allowed brand owners to provide who were providing the same fundamental goods and services through an updated means, method, or format to basically update their descriptions to cover these evolved goods and services. So if you were making printed children's books, you were all of a sudden eligible to amend to downloadable electronic children's books if you no longer provided them in that printed format. Well, to the extent parties seek to enforce these rights, they're still going to have to deal with the checkered landscape, right? We're not solving for that. There's always going to be some fact-based evaluation of the scope of the rights and likelihood of expansion by the brand owner and commercial relatedness between the real and the virtual goods. But this is an opportunity to update those registrations, especially for those who are adopting new technology. And it might help brand owners with the current uncertainties they face and give some long-term direction in terms of filing strategy. Of course, with this kind of a pilot, Trademark Office might also need to consider what kinds of specimens are appropriate to prove use. There's little precedent in the space, and the existing examples presented that the Trademark Office put on a presentation on registering trademarks for newer technologies last month, and those examples were great and helpful. But they only give direction on super straightforward use cases. NFTs offered for sale in a marketplace where there's a buy here button. Unfortunately, that kind of evidence isn't always available. For instance, marketplaces look different across different chains. What if the NFT is
warning for you?
Thank you.
Marketplaces.
What if the NFT isn't available on a traditional marketplace or marketplace at all, right? Like Jackie from ASICS had mentioned, it's a fashion brand using it to illustrate provenance. So we need some further guidance on non-traditional specimens, and I think that would go a long way in giving brand owners peace of mind that they have the requisite use. But in that same vein, we should also be considering class coverage, and this is an issue that's come up a lot. In the interest of time, I'll sort of shortcut this, but 9 and 35 are core. Everyone's focusing on those. There are some big question marks around what we should do in 36 and 42 as alternative vehicles for these service offerings. We're seeing language being stricken from the ID manual, things like issuance of tokens, and being replaced by archaic terms like prepaid vouchers and gift cards. And so we're likely to see an uptick in programs like the Consistency Initiative and others, used to harmonize this language. So getting ahead of it with additional direction and clarity on appropriate scope is likely to be invaluable going forward. Thanks again for having me.